All right, and this appears to be criminal trial division and also family violence. There's a new case.
Pick.
Oh, it's Pick.
Yes.
Hi.
So Judge, just the backstory. So I've been coming to court repeatedly on the family violence case. There's been I guess a case with Pick, or a couple cases with Pick that have been kind of percolating. And then he was indicted, I guess, on how many counts?
I'm gonna get out my
Okay.
multiple judge. 8 counts, Judge.
All right, and is that on the kidnapping?
Yes.
Okay.
So I've been appointed to those cases now. I don't have any discovery on them. So obviously, I think the discussion all along was those are going to be the cases we were going to try. I'm a bit taken aback by the 8 different counts, a little, I think, overreached by the previous prosecutor. But nevertheless, I'd ask for I guess, discovery deadline so I can try to get the discovery on those new cases and figure out what I'm doing with them. And then on a side note, he tells me when he was magistrated on the new cases, no bonds were set.
Mhm.
So, which I found kind of unusual, but I don't know who did the magistration, but I'd asked the court to set bonds on those cases. I don't see why he wasn't given a bond when he was magistrated.
All right, and this is on the newly indicted case?
Yes.
Yes, Judge, with this court, so it's actually you have to report.
All right, do y'all want to proceed with an oral motion to
Yeah,
set
I
bond?
would, Judge.
And State, are you prepared to proceed?
I think this would be enough, Judge. I think you mentioned that.
All right, thank you.
Yes,
And what I can tell you is on the 2024 CR 0924 case, which is the assault family household. Let me see. Okay, he has a bond on that one.
He was out on bond when all with these new cases finally got indicted.
Okay. All right, the court is calling 2025 CR 013272, State versus Jonathan Dreamer. Can I have parties announced for the record for the state, for the defense?
Robert Mauer.
And are you Mr. Dreamer? All right, defense, are you requesting a bond?
I am, Judge. I'm requesting the court set bonds on the cases that he was magistrated on, but no bonds were set.
All right. Any objection to the defense having an oral motion to set bond?
None, Judge, but the state would like to proffer a report from this court's review.
All right, just one moment. Any witnesses?
No, Judge. I mean, I can tell you, look,
I'll
for
need,
purposes of the bond hearing, I guess I can call Jonathan Dreamer.
all right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
They need to speak louder.
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jonathan Dreamer.
All right, defense, you may proceed.
Jonathan, I know you've been incarcerated
Just one
since,
second, I'm sorry. Everyone, please whisper, we're on the record. You may proceed.
you've been in custody since you were picked up on these new charges, correct?
Yes, sir.
Do you, I guess, once you were arrested, you lost your job, is that correct?
Yes, sir.
Do you have any family who can help you make bond if you're given one by the judge?
Yes, my my niece and my sister.
Okay. And do you know how much money they have set aside or can get for bonds?
They don't make much, but I know they could at least get like 1,000.
Okay. And do you have bail bondsman you can work with that you might be able to work payment plans with?
Cowboy bill.
Okay. All right. I have nothing further to.
All right, state, any questions?
Mr. Dreamer, were you on bond in the family case when we picked up these cases? Or did these have to prior to the family case?
Judge, I'm gonna object to any. I mean, if the court wants to review the records, I don't want my client talking about dates, but I think, well, the court's aware and there's judicial record that my client was out on bond. These cases were filed at large when we were coming to court, and then he got picked up once they got indicted.
All right, so here's the court's question.
Yes.
The case that he is indicted on that he doesn't have a bond for,
Yes, Judge.
what is the alleged offense date?
November 8th. That might be a stenographic. error.
Yeah, that's an error.
So November 8th of 2023.
All right, and then the case that he previously had bond for, you're saying the assault family violence case, what's the alleged offense date on that case? All right, state, you may proceed.
No additional questions.
All right, I have a few questions, and it's questions that are related to bond. First, in defense, if you know the answer to this, you can answer it, or your client can answer it. Has there been any type of mental health diagnosis in the past, or any type of mental health medication that has been previously prescribed to your client?
There's nothing that I'm aware of. Did you have any sort of previous psychiatric?
No.
And there was, I know they do mental health evaluations at the jail, but I didn't receive any red flags
Okay.
on that at all.
And then my other question, in the past, has there been any type of drug use?
Not that I'm aware of.
No.
All right, any other questions?
None from the stage.
All right, any other witnesses?
No, Judge.
State, any witnesses or evidence for the court to review?
Yes, Judge. Judge, at this time, I would offer state's one issue just for the purposes of this court's review and hearing.
I have no objections.
Okay. States exhibits 1 and 2 are admitted for purposes of this hearing, and the court will review. All right, the court has reviewed states exhibits 1 and attachments. Any other evidence?
No other evidence, Judge.
All right. Defense, what amount? I'll just figure out what amount you're asking for, and then I'll hear argument.
Well, Judge, I
Defense counsel is strategically asking for the low end of the bond schedule here. Why? Because while some of these charges might stick, a lot could potentially be dropped or reduced. This is classic courtroom chess. Protect the client's liberty while acknowledging the reality of multiple indictments. Watch closely. These small moves can make a huge difference.
I can tell you, I was a bit taken aback by the sheer amount of charges that were filed, because I think the previous discussions didn't quite encompass all of those. I mean, obviously there's a bond schedule in place, but I'd ask the court to look to the low end just based upon the sheer number of counts that were filed. I think a lot of those are probably going to go away. I'd ask the court to set bonds on each charge at $25,000. I think it'll be hard for them to make it, but it still gives them an opportunity. I don't think there was GPS in place before, but that might be appropriate in this circumstance if the court is concerned about safety to the community.
State,
Judge, is this court setting bond by case number or by county?
case number.
Case number?
Yes.
Yes, the cumulative bond on this case be 150 with full GPS included.
Well, if it's all in one case, then I'd ask the bond be set at 100.
All right, and I'm saying all in one case because it makes it easier for the clerks.
Sure.
And so this is under cause number 2025 CR 01327. And what I can tell you, Mr. Dreamer, according to new case law, you're not entitled to bond, but I haven't received the evidence on the previous allegation of the assault family violence to make a decision to deny you bond. But this is what the court will do. There's to be no contact with the complainant. There's to be full GPS, waive fees, and the court will set your bond at $200,000. And I need a date for discovery on this case, please. And counsel, I know the previous discovery date on this case was today, but you've been in jury trial.
Yes, ma'am.
All right, so if we could do a discovery date for that last week in December.
I'll be here.
All right, so your discovery is going to be December 18th. And if someone, I'm going to give you all a blank form. If on the blank form, if you could write down the court's ruling with regards to the bond motion so that the clerks may have it. All right, could you grab that from the printer, please? And counsel, if your client can just sign that acknowledging that he's on notice,
Yes, ma'am.
and if all parties will sign that. All right, yes. Thank you.
Yes,
Is there anything else?
No, Judge.
Any questions, Mr. Dreamer? Any questions? All right, thank you.
Thank you, Judge.
You're welcome.
Yeah.
All right, then let's go back on the record. State's Exhibits 1 and attachments were offered for review. It's my understanding from State and Defense that it was not to be admitted into evidence. So State's Exhibits 1 and 2 are withdrawn. Thank you.
Thank you, Judge.
Amani Robinson, before she comes up, counsel, is this a motion to revoke?
It is.
Have you all conferred on the motion?
I haven't, Judge. I just got retained on her last night. So I got here to get a motion to set the bond for her.
All right, could I see the motion to revoke?
I did have it, Judge, because Ms. Abrams had sent me a copy.
On Ms. Robinson's case,
Mhm.
we are not ready to proceed on the motion to revoke.
Okay, oh no, we're just doing the bond.
Okay, I just wanted to let you.
Sure, no problem. And counsel, I wanted to see the motion to revoke to see if there's any need for no contact orders.
I don't believe so, Judge, but I don't want to,
Well, I mean, based upon the
Yeah.
number one that's in there,
what's number one?
assault.
Okay.
And I don't know why this isn't pulling up. 008-663. I'm gonna try to look this up by name because Odyssey is not pulling her up. All righty, Imani Robinson.
And I conferred with the state this morning, Judge, and we did reach an agreed amount. If the court
All right.
honors that amount.
Date. Imani Robinson, the court is calling 2024 CR 008-663. State versus Imani Robinson. Could I have parties announced for the record?
David Andre Woodard for Imani.
And are you Miss Robinson?
Yes, ma'am.
All right, defense, you're here requesting a bond, is that correct?
Correct, Judge.
All right, and defense, what bond amount are you requesting, or is there an agreement? I'm sorry? All right, Miss Abrams,
Yes.
and state you may be excused. On this case, she's currently on probation. Is there any conditions that need to be added as far as any no contact orders, any mental health or drug issues that need to be addressed with the bond? Twenty 2024 CR 008-663. All right, thank you. Has your client, since I've last seen her, has there been any type of mental health issues, any mental health diagnosis?
Not to my knowledge, Judge.
Okay,
No, Judge, she doesn't wish to speak.
all right. There's going to be, the court will follow your agreed order. There's a $7,000 bond, full GPS waive fees. There's to be no contact with the complainant.
Quick transition here. Notice the agreed bond for Imani Robinson, $7,000, GPS fees included, no contact with the complainant. Compare that to Dreamer's $200K. Same courtroom, very different circumstances. Context matters in criminal law, and it's why each case must be individually assessed. Audience question: do you think this seems fair? Why or why not?
And the court's order is to be entered on November 21st, state. And the reason why it's November 21st is because the complainant needs to be notified that she'll be released. If state, if you're able to contact the complainant today, then it can be entered into the system today. All right. And then Ms. Ferguson, if you can set this, counsel, do you have all of the discovery?
I don't judge.
All right. Norma, if you can set this for the first week in December. All right, it'll be set for December 4th. And probation, that's for them to obtain the discovery. All right, is there anything else?
No, Your Honor, thank you.
Right, and if you'll check with the state and come back to me on whether or not the order should be placed in the system today or tomorrow.
Okay, thanks, Judge.
All right, thank you. All right, so I'm assuming the sanity issue was addressed
It was, Judge.
Yes.
and the results were same? All right, and you have all discovery?
While we were waiting for the evaluation, I did go through the file to see if we were missing anything. It turns out we were missing DNA and serology labs from Texas DPS private laboratory, so I did put a note on those things. So this one, I do use it, would be at least 60 days.
Okay, so the court has a hard time understanding with the nature of the case, why anybody didn't think there should be DNA.
I think so, Judge. The easiest thing would be just a word excluded and then we could.
All right, this is going to be set for jury trial and the plea deadline date at the same time. How long do y'all expect this trial?
Mark is at least 4 or 5 days, 6 days.
All right, Norma, I need a jury trial date, 4 to 5 days. And this needs to be set no later than February.
Courts indicated that if we're at trial and those results aren't back, that obviously they would be inadmissible.
Oh, I mean, I'll hear
Okay. All right.
Yeah. and make my ruling.
You do the February 10th.
All right, February 10th is going to be your jury trial date. What I can tell you, counsel, I don't understand. We've been on this case since March, and it shouldn't take a year to obtain DNA evidence.
I agree. Judge.
Otherwise, something shouldn't be indicted. Yeah. It's like, don't indict it. All right, so we're going to be back for a jury trial date and a plea deadline date on February 10th, 2026. So everybody be expected to go.
And here's a real-life legal wrinkle: DNA evidence taking months to return. The judge even says it shouldn't take a year. This highlights a major procedural bottleneck in criminal trials. Delayed evidence can literally stall justice. It's a reminder that courtroom battles aren't just about people. They're about paperwork, labs, and the timing of science, too.
Miss Sinwell, you'll be brought over dressed for trial. You'll be dressed in whatever clothing whatever civilian clothing you have at the jail. If you wish to be attired in something differently for trial, you'll need to do a clothing exchange. Counsel, my understanding, the jail has changed that. So you need to have her clothing exchange done within 72 hours of trial.
You mean before 70 hours before trial? Judge? Okay.
Yes. All right, thank you.
Thank you, Your Honor.
You're welcome.
Have a seat, ma'am.
I have one more, Judge. I think it's on the same.
All right, who is,
On page 8, Judge, just one down, Danny Rita.
Have a seat.
all right, have a seat. Danny Rivas.
Then will.
All right. So what is happening with this case?
Judge, an offer was made today, conveyed today. My client would like a little bit of time to consider that offer.
All right, Norma, set this for the first week in December. That will be your plea deadline date. The court will not extend it any further. All right, we'll see you back on December 2nd.
Thank you, Your Honor. Appreciate it.
All right, thank you. Once you sign the reset form, you excuse, and if you could make sure I have the acknowledgement of discovery.
I will, Judge. Thank you.
All right, thank you.